Thank you guys. I am sorry that I'm hopping on right on the hour. Um, so thank you for coming. There's a handful of you, so that's great. I'm going to share my screen. I am dog sitting for a Yorkie who is very loud, and I had to find some place to put him. So that's why I'm late. Okay, so we're kind of launching a new series, if you will. We really want to aim these contract trainings now for like the meaty middle. For those of you who have been practicing already, we're not like, teaching the basics on buyer agency, etc., but really want to talk about those one-offs that come up and how to handle them. So February, we're launching this. Today, we are going to be talking about as is, and what that statement really means. A lot of our content will just be coming straight from the WRA, Legal Hot Tips Library. And then also a lot of this, of course, as with all of our topics, informed by like the previous week's questions. So this was actually a good timing for this one. I have an agent who is selling a flipped home and the seller wants to sell it as is, right? And what does that really mean for a seller when they wish to sell as is? So, all right, well, first up, getting to the heart of it, we need to kind of determine what a seller is trying to accomplish with an as-is sale. So, most of the time, the responses are, again, kind of dialing it back when you're at a listing appointment and a seller expresses to you, I want to sell this as is. So we need to get to the heart of what they're trying to accomplish. So common responses, seller does not want to make repairs or put any funds into the property. And I would say that's probably the biggest reasoning for why a seller wants to quote unquote sell it as is. A seller thinks that they are exempt from providing a real estate condition report so that they won't make representations. Another one is seller is aware of defects on the property and thinks they can hide or conceal them. It's more common than you think. And a seller thinks that they won't get sued after closing if they sell it quote unquote as is. So kind of breaking each one of these down, I'm going to start from the bottom up. So a seller wants to avoid litigation. First and foremost, anyone can be sued for anything at any time. So that is not taken away because an as-is language is added to a sale. It's not the bulletproof vest that a seller thinks that it is in terms of avoiding post-close litigation. So they're not exempt from making disclosures about a property. The buyer is relying on a seller's representations, of course, and if proven that the seller did not disclose defects to a buyer, the buyer could have misrepresentation claims. So again, I think a lot of times sellers think that if that as is language is in there, then they've wiped their hands of being liable for anything after closing, and that's just simply not true. So we want to make sure that we are educating our sellers on all of this, but for that, first and foremost. I will like to say at any time too, please, of course, stop with questions. We love it when there's dialogue. All right, seller knows condition of the property and wants to conceal. So this is a question that we get a lot in terms of flippers and whether or not they are exempt from filling out a real estate condition report. So it is total urban legend that a flipper is exempt from filling out a real estate condition report. So just because they have never lived on the property does not make them exempt. And in a little bit, we're going to be going over what the seller's refusal form looks like. Um, but it's arguable that they know more than anything, more than anyone about the state of that property. Presumably they're in there day in and day out, working on the home, making those improvements. So they are not exempt from filling out a real estate condition report. A lot of times a flipper will choose to not fill one out. And again, I can show you guys the appropriate box that they would check if they don't want to fill out a real estate condition report. But they're not exempt. Again, just because they've never lived on the property doesn't mean that they are exempt from making disclosures. And then sellers just generally think that they are exempt from filling out a real estate condition report. So we're going to refer to that seller's refusal to complete the real estate condition report. I'll show you that in a minute. Is a seller truly exempt? So again, it spells out all of the exempt categories. If they are, then you're going to mark one of those options indicating which category they fall under. If they are refusing to fill out the real estate condition report, then the seller, with legal advice, may check box 14, which is the seller refusal to complete. And then, as an extension of this, we as licensees still have an obligation to disclose any material adverse facts. And we'll use the disclosure of material adverse facts form. So helping out an agent this morning on a listing where the seller again wants to express that it is sold as is. I believe they are exempt from filling out the real estate condition report. But we know of a issue with the condo. So that agent is going to have to fill out a disclosure of material adverse facts if the seller does not want to make the disclosure themselves. This is what the seller's refusal form looks like. So starting at the top, again, just filling in the information. You're going to identify yourself and your firm on line 5. And then I mean, it's pretty detailed. So Wisconsin statutes requires a listing agent to make inquiries of the seller regarding the condition of the property and requests that the seller provide a written response to the inquiry. Statutes indicate that a property owner shall provide a real estate condition report when the property includes 1 to 4 dwelling units and a vacant land disclosure report when the property does not include any buildings. So the listing agent provided the seller with the following condition reports and asked the seller to complete them. Then you're going to strike out which ones you did not provide so you can leave open what you did provide them. So 9 times out of 10, you would be striking the vacant land disclosure report and the seller disclosure report commercial and leave the real estate condition report option open. Then you're going to check line 14 or line 20 as applicable. So the seller refuses just to complete. So we have a agent who works with a ton of investors and a ton of investors who flip the homes. And one in particular is constantly checking line 14, seller refusal to complete. Again, he's not exempt, but he knows that he needs to make an indication one way or the other about it. He simply cannot just not fill out the real estate condition report. He needs to indicate that he's just flat out refusing to. So that's, again, the appropriate box would be this line 14. So the seller acknowledges that the seller has refused to provide the listing agent with a completed RECR or other disclosure report for the property. The seller understands this refusal may be disclosed to potential purchasers and has been advised that the seller's refusal to provide this report does not release the seller from any disclosure obligations under the Wisconsin statutes. Seller should consult with legal counsel regarding the seller's disclosure obligations in an as-is sale. So this now more than ever should tip us as listing agents, okay, then I am going to do even more diligent effort to to inspect that home because then now, Mr. Seller, I have to disclose what you're not willing to disclose. Again, I'll show you that form in a minute here. But we have a duty with all listings, not just listings that are quote unquote as is, we have a duty with all listings to inspect the property at the time of listing the home. And, in a more traditional sense, if we have a seller who is completing a real estate condition report, on our inspection of the property, if anything contradicts the real estate condition report that the seller has filled out, we need to make our own disclosures. So that's just a reminder.
Hey, Steph, I do have a question.
Yes, Emily.
So, what if a seller is a personal representative now who has never lived on the property, but they will be the owner after a deed is done?
So if they are an executor of the estate and they are exempt and they've never lived on the property, so we'll talk about this. I'll go through these on lines 20 through 28.
Okay.
But they still need to make disclosures on a home if they know about it. It doesn't preclude them from making a disclosure about something that they know
Sure.
of. So again, that's where, and I'm just gonna, if it's okay, Emily, if I can use you as an example.
Yeah, go right ahead.
Emily and I have been talking this morning because she has a condo that she's about to list, and the stove is not working. So we need to make that disclosure ourselves if the seller is not willing to. But if a seller who is exempt from filling out a real estate condition report, that doesn't mean that they can't fill out a real estate condition report. If a seller knows of something, they absolutely can just go ahead and fill out the real estate condition report, even though that they are exempt. Um, so again, I think the conversation always is, you are exempt. We can indicate that. If I know of anything that you have told me, then I need to make the disclosure myself on my own form. And again,
Perfect.
I'll show you what that looks like. Um, Leah Bird, I think.
Yes,
Oh, where are you? Okay, there you are.
from,
I didn't see
from
that
the
you had a question. I had my
oh, that's okay.
yeah.
From the buyer side, recently I've seen at least twice where they have the refusal in place of the seller condition report
Hmm.
with nothing checked at all. It's just there. It has all the information, the seller's information, the address, the agent's information, but none of the boxes are checked. Should I not have a buyer's initial that?
I would, okay, so if you mean that it's just completely blank and they're not saying yes or no or um not applicable, where it's just
Right. None,
okay.
well, they fill in their information as far as the seller's name and address and agent's name, but lines, what is that, 13 through 28, nothing is there
Oh, on the seller refusal form.
on the refusal form, yes.
Got it. Okay, well, I would push that back and ask which one of these applies to the current seller.
Okay.
Absolutely. Yeah.
Okay.
Um, I mean, otherwise it's just completely obsolete, you know?
Yeah, and that's what I thought. And like I said, I saw it more than once. So I'm like, is there something I don't know? But
No,
yeah.
definitely not. Yeah, one of those should be checked.
Okay.
So,
Hey, Steph,
yes.
it's Teresa. So I'm still kind of caught up on like the seller refusal to complete. So they're by them saying they refuse, like in the example of that investor that just always refuses to complete the RECR.
Yep.
And it says that they're not exempt from actually having to disclose. So what are the ramifications on them, or when does something come back to them legally that would hold them accountable to the fact that they refused?
Well, I think that goes back to um, them not being shielded from litigation post-closing. So if something were to come up after closing that the seller that or sorry, that the new owner feels that the prior owner did not disclose, then they still have the same rights that they always had of going after misrepresentation. So
Okay.
that's kind of the realm um, where any consequences would take place
Okay.
should they know about something and then don't disclose it. So,
Okay. Thank you.
um, and we'll talk about like a buyer's agent's duties in this in a minute here too. So, just extra precautions that we should be taking.
I do have
Um,
a very quick question then, Steph. So then for my situation at the time of listing, and my seller certainly hasn't, said I'm not going to do that or anything like that.
sure.
But so for as far as, I will obviously ask if they're okay with doing that, or if, they really don't know anything else about the property. So if it does end up being the refusal to complete, because right now he's just the, personal representative. So would he then check box 14 and then I would just disclose?
Nope.
Okay.
Yeah, this is a good segue into the rest of this form. So, if the seller is not required to complete the report, so again, if they're
Oh,
exempt,
20.
yeah, then we're gonna skip down to 20.
Got
So
it.
the seller hereby asserts that the seller is not required to complete a condition or disclosure report for the property because the seller, and there's truism on all of these. So a seller is a personal rep of an estate and has never occupied the property. Seller is a trustee and has never occupied the property. The seller is a conservator and has never occupied the property. Seller is a fiduciary appointed by or subject to supervision by a court and has never occupied the property. So all of these exemptions have to be coupled with the fact that the seller has never lived on the property. So, in the case of and this is often the case when a child or when a child is um, the executor of an estate, sorry, a daughter or son at this point, adult daughter or
Sure.
son. Thank you. If they had lived at the property at any point, even if it was during their childhood, they are not exempt. So, even if it was decades ago, they are technically not exempt from filling out the real estate condition report, even
Okay.
though it has been years that they've never lived on the property. So, just because you are a personal rep of an estate, a trustee, a conservator, or a fiduciary appointed, that doesn't make you exempt per se. It has to be coupled with the fact that you've never occupied the property. So,
Got it.
um, oh, and then other ones. So this is applies for new construction. So the property includes 1 to 4 dwelling units, but has never been inhabited. So a builder does not have to fill out a real estate condition report because the property has never been inhabited. And that's what I think a lot of flippers feel like they fall under because they had never occupied. Um, they're again making improvements on this home, flipping it, never actually living in it. But the property was habited at one point or another. So again, they don't fall under like the category of a builder. So, and then the transfer is exempt from the real estate transfer fee under Wisconsin statute 77.25. So this could be like a church. If they were exempt from the real estate transfer fee, they do not have to fill out a real estate condition report. But yeah, I would say our biggest questions around these exemptions, again, more so fall under, again, like these traditional personal rep situations where, it's their family home, their parents lived there, for decades. They're now selling it on behalf of them after they've passed. But they still need to fill out a real estate condition report if they lived at the home. So,
Can I ask one question?
yes, Tammy.
Okay. So in the past, I've done, some sales for, people that were personal reps or trustees of an estate. The
Hmm.
attorney provided their refusal to complete the RECR. And
That's great.
yeah, they have their own, well, he typed up their own modified, I guess, not the WRA's form, but um, there were falsehoods that I had learned later because they had actually grown up in the home. A
Okay.
couple of them had lived there previously, but the attorney had them fill it out at his office. Now my question is, now being aware of this a couple years later, would we want to actually have them fill out the proper information and have that on file rather than going with the attorney's form that they had them complete?
I would tread lightly in the sense that, they've already consulted with an attorney on it. So if there was a post-closing issue, you know, our hands are kind of off of that. Um, I think where my role would be if I learned that, I would probably ask to go back to the attorney, Mr. Seller, can I ask this question directly, or can I have you ask the question, or just point out that you did live on the property at one time? Is this still the proper form that you would have me fill out, Mr. Attorney? I think that's how I would proceed with that.
Okay,
Yeah.
thanks.
Yeah. Um, okay, any other questions before we move on to the next form? Okay. So this is the form that we as licensees will use to fill out material adverse facts that we see. So beginning at the top here. So I'm licensed in the state of Wisconsin as a real estate broker or salesperson. You would strike one to leave the other open. Um, Per Wisconsin law, requires the real estate licensees to make prompt written disclosure to buyers and sellers regarding material adverse facts and regarding information suggesting the possibility of material adverse facts. In other words, the law says that I should make sure that you know about certain possible problems that have not yet been reported to you by other parties, licensees, or professional inspectors. I like that layman's terms sentence. An adverse fact is a condition or occurrence that is generally recognized by a competent real estate licensee as having a significant adverse effect on the value of the property, as significantly reducing the structural integrity of the property, or as presenting a significant health risk to the property's occupants. An adverse fact also includes information that indicates that a party is not able or does not intend to fulfill his or her contractual obligations under the offer to purchase or other contract. An adverse fact is material if a party indicates it is significant to them, or if it is generally recognized by a competent real estate licensee as being significant to a reasonable party, to the extent that it would impact whether or not the party enters into an offer or the party's decision about what terms and conditions should be in such a contract. As a Wisconsin real estate licensee, I am thereby obligated by law to disclose the following information indicating a material adverse fact or suggesting the possibility of a material adverse fact. And then you would just simply list what you see. You don't have to make any comments about what you see or make any inferences about it. It's just simply, crack in the basement wall, leak or evidence of a leak, um, you know, broken stove. So, I just want you guys to have peace of mind knowing you don't have to like make an explanation about it. You're just simply listing what you see, um, as material adverse, as a material adverse fact. Again, in the cases, we'll go back to Emily's, example. If the seller does not want to fill out a real estate condition report, they choose, I'm exempt from filling it out, so I'm not going to fill it out, then it's on us to make the disclosures. We are not exempt from our obligations to disclose anything that we see. Okay. All right. Then next, this is kind of where I can't stand the term as is, just because of the myths around, inspections and negotiations, when a seller expresses that they are selling quote unquote as is. So, sellers do not want to make repairs or put any funds into making repairs. So we'll get that a lot, and that's completely fair for a seller to say, I just want to sell it in its current condition. I don't want to make any repairs. I don't want to put any funds into the repairs. And that's fine to say that at the time of listing it. But no one has a crystal ball on what an inspection or a test might reveal about the listing. So a listing agent can communicate to to the buyer's broker, to the buyer's agent, what the seller's intentions are. But if there is an inspection contingency, there's no way of knowing how a seller will actually respond to complete a transaction once an amendment or a notice of defects is provided. So this is like the biggest thing that I want sellers to understand is that as is does not preclude a buyer from attempting to negotiate based off of what they find in an inspection. Um, and a buyer arguably will probably be more diligent about making sure that there's an inspection contingency or a testing contingency in place, if they don't have any other information about the home. But I think that's like the biggest myth around as is, the terms of the inspection contingency still play out as normal if a seller is accepting an offer with an inspection contingency. So, the likely outcome then might be like, let's say there is a $10,000 foundation repair that is revealed, throughout this process. We can say the likely outcome would be that instead of that seller actually making the repair, maybe it is a reduced price or a seller credit. Um, but again, that buyer can attempt to negotiate with an amendment. They can serve a notice of defects if it comes down to it. If the seller is just flat out saying, no, I'm not going to do anything, they can still provide that notice of defects. And then the seller still has their same list of options that they always had once a notice of defects was given to them. If the buyer did not give that seller the right to cure, then that deal is dead right there. If the seller was given the right to cure, then same rules apply. They can choose to fix that foundation or just release the seller. Excuse me, release the buyer. Um, oh, 100% Nicole. Thank you. Yes, and I'm saying that, just reiterate that tenfold, no matter what, if it's an as is or not, I always say we should be attempting to negotiate, always before we just deliver that notice. Again, just in case you don't know how a seller is going to respond. So thank you for that. Um, so any other questions or comments about that? Okay. So then as a listing agent, and some of this is just repeat of what I've said, but from the licensee standpoint, the statutes require that we perform a reasonably competent and diligent property inspection and disclose material facts and potential adverse facts to the parties in writing. Again, that doesn't change because it's as is. It's not excused or waived. When the buyer is purchasing as is, it is very important for the buyer to know the condition of the property. Generally, the buyer has expert inspections of the property as a condition of the offer, but this does not excuse the licensee from the duty to assure that all known material defects are disclosed in writing to the buyer. And then as a buyer's agent, representing a buyer, when the buyer is purchasing as is, it is very important for the buyer to learn as much as possible about the condition of the property. So consequently, the buyer may include testing and inspection contingencies in the offer as typical. Maybe maybe they're more inclined to include a testing contingency as well, you know? Again, the inclusion of the term as is does not preclude the buyer from conducting testing and inspections per the contract, if that's what it was agreed to in those initial offer negotiations. Then the parties will work through each of the inspection and testing contingencies on their merits. Again, the provisional language is true no matter what. So it plays out per the inspection contingency language as normal. Right to cure still applies, etc. And I think that's all I have. Last slide. Yes. So I'm gonna stop share, kind of open this up to more. Any other questions that you guys might have? Or just comments in general?
Two things.
I have a question. I have a question because I feel like sometimes I work with sellers that just say, well, I just want to sell it as is because they don't want to do the repairs. I don't like putting the verbiage in there. But what I saw on some of your slides is that I could put verbiage in there so that they know that I hear them. That I could say, you know, sellers do not want to perform any repairs if needed, or what was some of the verbiage that you talked about? Versus saying the dreaded as is verbiage.
No, I think that you can still include it. I think it's just more educating the seller on what it means for a buyer when they are having that inspection contingency. So, if we are accepting an offer with an inspection contingency, I can communicate to them that that is your desire up front, not to make repairs or give concessions on repairs. But again, until we have that inspection, we don't know what's going to come up. And it might be a big enough issue for a buyer that they want to, again, negotiate or just serve that notice of defects right away. Um, so it again, it's more of
Don't
just
put anything in the MLS then?
well, you can. I'm just, it's just, I hate to say it like this, but sometimes I just feel like it's a
Yeah.
meaningless concept, you know? It's just,
Yeah.
yeah, you're expressing this, and sometimes I actually feel like it makes more sense to add as is language after the inspection is negotiated, like in your final amendment, okay, now we're gonna come to an agreement on a $10,000 price reduction. This is as is, so you know what I mean? But um I mean, we have as is language that I can show you, and I'm sorry that I didn't include this in terms of
That's fine.
I've seen where agents have said seller prefers to sell as is. I think that gives some room for,
Yeah, we try to be
Sure.
professional.
negotiations. If something does come up and it's like, oh, okay, well, that's not a big deal. We'll take care of that or whatever. Or maybe their uncle can fix it because he's
Right.
licensed or something.
I
To
think,
your point earlier,
yeah,
I've
keep going.
seen an agent from the buyer side, an agent was offering on a listing that said as is, but they got a new roof put on. And that's a big ticket item. So
1,000%. Yeah.
I
I think
mean,
that's
I wrote on an as is property and there was probably $4,000 or $5,000 worth of mold remediation, and I told the seller about it and they were like, well, we'll do it. I was like, okay. So
yeah.
I mean, versus just sending the notice that says, well, there's mold, we're out. I mean, it is worth having a conversation. I just know that sometimes it eats me on the buy side when we have an inspection and then I talk to the agent and they're like, well, we're selling it as is. Well, had we known that, we may not have written an offer. So I think it's important to communicate that and include it. I just don't know where and when.
Oh, sure. I mean, I think that's just also it all goes back to the initial negotiations too, right? I mean, sometimes when you're making an offer on a home and that listing agent is saying like, this is as is, and maybe the buyer is aware of issues or can just visually see that there are issues that's a fixer upper, maybe that's all part of the conversation with the initial purchase price, the initial offer price. So then when you're kind of going back to negotiating on an inspection, maybe that's when the listing agent pulls it out again, like, hey, we already like made up for this at the initial offer stage. Like we already made tons of concessions on all of these things. They're not going to make any more. Again, I think it's just a negotiation tactic to say that sometimes, but it doesn't, again, the buyer has the option of delivering an amendment, delivering a notice of defects, so I, if they say that, okay, that's fine that they're selling, that they want to sell it as is. That doesn't mean that this repair isn't so big that my buyer wants to move forward on it. Does that
Would
make
you
sense?
agree? Would you agree to have the sellers make sure that's reflected in the price if they are firm on the as is? Like
That
making
possibly, I mean, I think it's hard to, I mean, we
without
as
knowing.
listing agents, we know it's always hard to price these things.
Yeah.
I mean, again, I guess maybe that's more of, if you're really looking at a property that's dilapidated and you want to go that route, you could, you know, do that legwork up front before you're putting it out on the market and getting estimates for things, and then just like putting that all into the price um, consideration, the listing price consideration. If you were going to list it at 250 and then you learned there was I don't, I don't know if that's a good strategy, but you could just get the estimate and then reduce it from there. But too, depending on the market, Jay just talked about this a few weeks ago at Ignite. It's like getting this information up front, supplying it to a buyer, and if the market's hot enough, maybe a buyer is willing to just take it on themselves, depending on the location, on the competitiveness, right? So there's more than one way to skin a cat and approach these things, but. Yeah. Okay, I was gonna show you guys the as is language. Maybe. There we go. We'll be talking about this in the meeting tomorrow. You guys are all going to be experiencing this pop-up. Just going to hit skip. Sorry, guys. Okay, so as is in our clause library. So again, whenever you click into the additional provision space, the add clause pop-up will be an option for you. So the seller is selling the property as is and has not made any warranty or representation regarding the condition of the property. Buyer is responsible for determining the condition of the property and has included all necessary inspection and testing contingencies in this offer. So, I guess, yeah, this would be more appropriate to put this in an offer, versus, you could say, in a private remarks, stop short if you wanted um, to help communicate this in a listing. But But even I don't know. Again, I think it goes back to getting at the heart of why a seller wants to sell as is. You know, if there's not an attorney involved who is guiding them on making those concrete comments that they wanted in an offer, then we're really just going to get at the heart of what does as is mean to you, Mr. Seller? You know, so if you don't want to make repairs on it, if you want to sell it in its condition, that's fine. And again, back to the inspection contingency, if we're accepting an offer with an inspection contingency, same rules apply for the buyer. So, um, I think it's the heart of this is seller education.
So Steph, for my seller then, I think the best thing to do for me would I'll just ask them, I suppose, do you feel comfortable filling out this? And then at the bottom, just put at the bottom of the record, they can just say, we've never lived there.
100%.
Yeah, and then because I'm just looking at this seller refusal form, and it just gets my head just gets confused by it because yes, right now he's a, personal representative of the estate. But by the
Yes.
time closing comes, he's going to be one of the owners. So it's tricky.
Um, yeah, I guess it doesn't, I can think at the end of the day, it just does not, it doesn't mean that that he's not exempt from
Sure.
disclosing anything. So,
Sure. Okay. All right. Yeah, I'll just ask him then. Thank you.
yes. Okay. All right. Thanks, guys. Any other final parting words or comments?
Thank you, Steph.
Thank you.
Thanks,
So it's
guys.
good. I
All right.
appreciate you.
All right. We'll see you guys tomorrow on meeting. Bye.
Sounds good. Thank you. Bye.
Bye.